I would like to focus our discussion tonight on at least three central issues. One, what is the basic constitutional question of our case? Number two, how the judicial decision-making process unfolded. With this, I put a particular emphasis on the way in which the outcome was built, considering that, as I have described earlier, the liberal bloc of the court at that time was waning and was losing power. And therefore, with the presence of 4 Nixon appointees out of the 9 justices, the outcome of the US v. Nixon case was not predictable at all. So I also want to focus on that. And the third question, I would like from a contemporary perspective for you to shed some light on the lessons that we can learn from US v. Nixon. Perhaps for your generation, US v. Nixon may appear part of normal politics or normal constitutional politics. But in fact, by 1974, for instance, many scholars considered that that was the first constitutional crisis within the system since the Civil War. So we're talking about a century without this kind of shockwaves within the American political process and therefore the system of constitutional law. So I would like to address those three items. My aim is for us to try to disaggregate the ongoing predicaments of constitutional courts, avoiding to tackle political questions. So my vindication here, or my contention, is that it is very difficult at some point when the constitutional system is at risk or in peril to distinguish between political questions and constitutional questions themselves. The reality presents them in such intertwined way that it is very difficult to separate them, and therefore constitutional courts and constitutional judges are expected to fulfill their duty. However, there is a formalistic approach that, as this case showed, at least in the discussion between the members of the court, that some traditional arguments aim at trying to avoid at the most possible opportunity the political questions. But to underscore that Nixon was named as a co-conspirator not by a judge but by a grand jury, that, as you know, is a distinctive feature of American criminal system, that from some parts of the doctrine and also from the legal profession is considering the landmark or the underlying premise of a democratic government, the adjudication in criminal cases by grand juries instead of by specific judges. So regular rule or general rule is 4 votes in order to grant cert. However, in order to expedite a decision by this type of bypassing of lower courts, then you require a 5 vote to expedite. And it has to be justified under the basis of public interests, a national emergency, and the last case in which that happened were the executive orders of President Truman regarding the steel mills. So that was of national relevance, and they were trying to mirror the same criteria back in the 1940s with Truman with the case of US v. Nixon. Why does Rule 17C does not fully apply in this particular case? The problem was on the second requirement, if it was admissible on trial or not. If it is covered by privilege, then it is not admissible on trial regardless the relevance for the case. Exactly. So this is interesting, and in particular this will deal with the second question of our discussion today, which regards the decision-making process, because at the beginning, Lewis Powell, for instance, insisted that 17C was fully applicable. But then some reasoning, particularly particularly from Potter Stewart and Byron White, they said at the end that if those rules apply to regular citizens, therefore those thresholds for those two requirements have to be more onerous regarding those that are in public office, namely the president. So in this case, what we are seeing is not only that 17C falls short in terms of defining the rules in order to admit evidence, but also upgrades the threshold in order to set the president, or in this case, the defendant, free from relinquishing that evidence. The separation of power principle plays in this case in a very simple manner, using the grammar of Marbury v. Madison. As much as it is the province of the Supreme Court and the judiciary to interpret the Constitution, it is the province of the executive branch to deal with not only the foreign policy, but with the national security issues that involve the US government. Therefore, there is a privilege of the president in order to comply with the duties of his office to keep secret or confidential some areas that are particularly sensitive in his power to conduct foreign policy, particularly in terms of national or international security. Therefore, President Nixon's contention in all this case was that in most of his conversations with different aides and members of his cabinet and heads of different agencies that had meetings with the president, there was a number of sensitive themes and issues that were treated in those meetings. And therefore, from his, let's say, broad interpretation of his executive privilege, from his view, considering that those tapes involved national security issues, therefore they were covered by his executive privilege, and then hence they have not to be surrendered even if they are required by a subpoena. So that is the reasoning from the vantage point of the president. The point is that what he claimed as national security, in fact, was that he didn't want to surrender the tapes because those tapes showed that he was involved in the cover-up of Watergate and that he ordered the payoff for those implicated, and he gave orders to his legal counsel at the White House and other aides to proceed accordingly. So the president at that point knew that if he surrendered the tapes, he will be considered involved in the conspiracy. The point is triggered by an utterance of President Nixon when he said that he would like to submit this case to the court because after the court decides, he would know how to move forward. That was tricky, to say the least, because it seemed that President Nixon implied, advised by his attorney, that the powers of the court in this case, since from their vantage point involved exclusively the executive branch, the nature of the participation of the court, instead of being an adjudication, it would be an advisory opinion. The mere idea of submitting or filing a motion to the court to request its advice in order to ascertain how to comply with an order of a lower judge is preposterous, because with that action, what the executive branch was conveying is that they were not subject to the rulings of the courts, regardless if it was the Supreme Court or lower federal courts. Therefore, the underlying question, and which made all justices, including Warren Burger, so uncomfortable with this decision, is precisely that it was a very adamant position from President Nixon that what he was asking of the court was very much like he was asking as a client an advice from 9 attorneys at his service. That made no sense. And that's why, of course, it is enrooted in the concept and the operation of executive privilege, but its reach goes further, meaning that in this particular case, the court, with this unanimous decision, signaled to the executive branch that even the actions within it were susceptible to be scrutinized by the court in a final analysis. So that is key important, because the only precedent in terms of the reach of executive privilege based on national security arguments was precisely, again, from the Nixon administration, the Pentagon Papers. And in that case, the rationale and the thesis from the court was very clear, that in a free society, authorities and the government have to be deferent to the pressure of public opinion.